will call the meeting for Thursday, March the 3rd to order. It's a very special day because we have one senator who's having a birthday today, who was also born on my mother's birthday. So congratulations to you and my mother. And the day before Gus's birthday. Clearly, it's most important. Okay, today before us we have House Bill 2489, which is amending some provisions of the TEFI bill. David, you want to give us an overview?
Thank you, Mr. Chairman. Good morning, committee. House Bill 2489 does make several amendments to the TEFI Act. There are some technical amendments just in there that kind of needed to be changed from the bill from last year. Just some incorrect subsection references, little grammatical errors, and some terminology just to correct that through the bill. And then the bill also then makes amendments to the definition of FIDFIN to just make it clear that it would be, the financing of a FIDFIN trust or the acquisition of alternative assets on behalf of or through a FIDFIN trust, or both. That language is put in there. The bill also then strikes some language on the fingerprinting. This is kind of an issue that came up with the FBI background checks. So this strikes the language, any other person of the post-TEFI related to the application deemed necessary. That language is being stricken, so it would just be those officers, directors, or organizers of the proposed fiduciary financial institution. So it narrows that fingerprinting requirement. Also amends the language regarding the $500,000 TEFI initial application fee. The application fee under the bill would be a non-refundable fee to be remitted in a manner prescribed by the commissioner. And until July 1, 2025, that fee would actually now be $250,000. And then on and after July 1 of 2025, the fee would be reduced to $100,000. The bill also amends language concerning the sending of TEFI assessment statements from the commissioner. The statement would be sent on July 1 instead of December 1. And the payment of any assessment would be made within 15 business days after the date the statement was sent in a manner prescribed by the bank commissioner. And the commissioner may allow installment periods for that payment, but not more frequently than monthly. The bill also amends language relating to the examination of TEFIs. The commissioner would not evaluate safety and soundness of a TEFI, but would evaluate the profitability, but it could evaluate the profitability of the TEFI, evaluate the TEFI's compliance with the state and federal laws, and the TEFI's information technology system policies and practices. The bill also then amends the powers of a TEFI to engage in trust business by requiring that such trust business be incidental to the engaging in FIDFIN transactions and to receiving, retaining, and managing alternative asset custody accounts. Then just add some language where to state when a TEFI may extend financing, such as through loans or extensions of credit. Requires a TEFI to disclose to a customer information required by rules and regulations of the commissioner to ensure that the customer is informed regarding the nature of the customer's transaction. And this was an amendment in the committee, taking into account the level of sophistication of that customer. Then also there's language added to whenever a TEFI by contract or otherwise causes a service authorized by the TEFI Act or the banking code to be performed on behalf of the TEFI, that performance would be subject to regulation examination by the commissioner as if it was also being performed by the TEFI itself. The bill adds language where an entity is appointed as a trust advisor. The entity would notify the commissioner in writing within 30 days of the establishment of such capacity to act as a trust advisor. And then finally, the bill amends KSA 39-1401 just to add fiduciary financial institution to the definition of financial institution, making a TEFI a mandatory reporter of elder abuse. Under the current law, any bank, trust company, escrow company, finance company, savings institution, or credit union is considered a financial institution and required to report elder abuse. So this just adds the TEFI to that list of existing financial institutions and to make them a mandatory reporter. You might see the House committee did make several amendments to the underlying bill. Mostly it was eliminating some provisions. The House committee had those sort of a comprehensive amendment that was agreed upon between the bank commissioner's office and beneficent. And so you see that they struck what was new section 1 of the bill that was concerning insolvency and undercapitalization requirements and procedures. There's stricken provisions relating to any new grounds for denial of TEFI applications, so that just remains with the current law there. Also struck provisions relating to bonds and insurance policies and capitalization requirements. Removed all the references to safety and soundness, as I said before, that safety and soundness is not a consideration in the examination of a TEFI. And then removed some provisions allowing the commissioner or the banking board to examine any aspect of the TEFI to aid in the understanding of the TEFI's business operations. The amendment also, the House committee also struck references to the customer's role in FinFin transactions and language requiring the commissioner adopt rules and regulations regarding asset class categories. That also was stricken. And then provisions relating to the termination of the pilot program were stricken as the pilot program that was taken care of under Senate Bill 337, with the date change to December 31, 2021. So that section was no longer needed in 2489. And I will say that the House passed House Bill 2489 120-0 on February 16th, 2022. And I can stay for any questions, Mr. Chairman.
David, thank you. Committee, are there questions? I see none. Thank you much. We will turn to the proponents on 2489. We'll start with Matt Sugar with the Kansas OSBC. Welcome, Matt.
Thank you, Mr. Chairman. Chairman Longbine, members of the committee, thank you for hearing our bill, HB 2489. My name is Matt Sugar, and I am a staff attorney with the Office of the State Bank Commissioner. I was involved in drafting many of the changes proposed in this bill, and I will provide an overview of those changes in this hearing today. Last session, the legislature passed the TEFI Act, which created a new financial entity in the state of Kansas called a Technology-Enabled Fiduciary Financial Institution. Two sections of the new law both charge the OSBC with the duty of recommending any legislation necessary to implement the provisions of the TEFI Act. The OSBC has learned a lot about TEFIs over the last year. We've been reviewing and administering the Act since its effective date of July 1st of last year. As we've learned more, as beneficent's application came in, or as we've just in discussions with beneficent, we've compared what we've learned to the statute and thought about how the statutes will play out in examinations and applications, and we came up with some recommended changes. Our recommended changes were contained in HB 2489 as introduced by the Joint Committee on TEFI Oversight following its December meeting. Earlier this session, the parties discussed the bill further, and we agreed on many points. We ultimately settled on a compromise, and the House committee amended the bill to reflect that compromise. The compromise bill has now reached this committee, and that is the bill before you in this hearing today. We agreed on several provisions that has been in the OSBC, and those provisions clarify issues unique to TEFIs, specifically what the OSBC will evaluate during an examination, that a FIDFIN transaction is often a sale from the perspective of a customer, that certain required notifications to the OSBC must be in writing and must be made in a certain time frame, when the first yearly assessment will be due, and that the OSBC will only require fingerprinting of officers, directors, and organizers of a TEFI, which resolves an issue that currently prevents the OSBC from obtaining background checks from the FBI. We also agreed to some changes that harmonize TEFI provisions with existing approaches for banks and trust companies, specifically to what extent a TEFI can engage in traditional trust business, that the OSBC can examine a TEFI's service providers, that initial fees are received at the time of application, that assessments are allocated and paid in July, how fees and assessments will be paid, that the OSBC can require disclosures to customers, and that TEFIs are mandatory reporters for purposes of elder abuse. We further agreed to several proposed technical corrections and wording improvements. For some of the remaining items where we do not yet agree, the OSBC and Ben agreed that it might be better to wait until after an examination to review those items. These items all involve the financial intricacies of a TEFI, or at least the intricacies of an exam. Specifically, these items are capital, insurance, and bonding requirements, limitations on concentration risks, what happens if a TEFI fails or stops operating, either voluntarily or involuntarily, the appropriate definition of insolvency for TEFIs, and whether the OSBC can examine additional items beyond those currently enumerated in the bill. I have attached to my testimony a table summary of our agreements with section numbers to assist in finding those provisions in the bill. I'm happy to answer any questions, and I appreciate the committee's support of the bill.
Matt, thank you very much. Committee, are there questions? I see none. Thank you.
Thank you.
Next, we will call on Derek Fletcher, President of the Beneficient Company. Welcome, Derek.
Thank you, Chairman Longbine, members of the committee. As Matt indicated, we've been working closely with the OSBC's office in terms of the examination process and really educating one another in terms of how the examination process would work with respect to beneficent. And as a part of that dialogue, have certainly agreed upon some of these changes that Matt mentioned that are largely administrative or grammatical in nature. And so we fully support House Bill 2489, and then look forward to working with the OSBC in terms of the other proposed amendments after the initial examination. And I'll stand for any questions as well.
Derek, thank you. Committee, are there any questions? Senator Gossage?
Not a question per se, but I just want to thank each of the proponents for the detailed changes. We have the page number, we have the exact information, and that's so helpful to the committee. Thank you very much to all of you.
Senator Pittman?
Thank you, and thank you for being here for both the testimonies, and I'll echo Senator Gossage's point of appreciating that you've worked through these things. One thing I'm curious about is, as we move forward and we're talking about kind of tabling the insolvency issue, do you have any thoughts on how that, what was kind of the point of contention that on that one point that we want to wait for that kind of provision? Because I think people do worry about that.
And it really reflected in terms of, one, the operation of a TEFI, right? And what assets, as you know, one of the aspects of the TEFI bill was the consideration of intangibles. And so part of that is working through with the OSBC as far as how do the intangible assets factor into the insolvency component, their understanding of the capitalization of the TEFI, the capital assurances provided by the holding company of a TEFI, and how those all intersect in terms of an insolvency computation.
Thanks.
Committee, are there additional questions? I see none. Thank you, Derek.
Mr. Chairman.
Are there any additional proponents to House Bill 2489? Anyone wishing to testify neutral? Anyone wishing to testify in opposition? I see none, so we will close the hearing on 2489. Committee, just for your future planning, we will hear 3 bills next week, and then my intention in that following week is to work all of the bills that we've heard in the second half, probably Tuesday and Wednesday of that week after next. One other item is there was minutes sent out for January 13th, 18th, and February 17th. I know all of you have very closely reviewed those. And so is there any comments, or is our motion to approve those minutes? Second. Olson moves, Dietrich seconds. Any discussion on the minutes? Senator Holscher?
They were the best minutes ever.
Glad to hear that. Any further discussion on the minutes? Seeing none, all those in favor signify by saying aye. Opposed, no. Motion carries. Committee, we are adjourned for the day. We will not meet tomorrow. We will not meet on Monday. So I will see you in here bright and early Tuesday morning.